Your Honor, Alexis Daneman. I also have with me today Margot Castleman, Sam Burke, and Reagan Jantzen on behalf of the Attorney General.
All right, thank you.
Your Honor, Chris Keller and James Mitchell on behalf of Pinell County.
Yes, I did receive the amici brief too. Is anybody representing any of those parties today, or is that?
I don't believe so, Your Honor.
Well, as you can tell, just by the number of people that are introduced themselves already, this is quite complicated and confusing. This is a motion for new trial filed by the plaintiffs. They have the right to argue that motion. I have responses by specific defendants, and I'm going to, after I allow the plaintiff to go first on the motion for new trial or argument, I will then have responses from each of the parties that filed a written response. I'll let them argue the case. If there's somebody that didn't file a written response that wants to argue at that point, I may entertain that, but maybe not as well. We'll decide then, but I definitely will allow the people that have filed written responses to the motion participate in that argument. And then when they're done, we'll hear again from the plaintiff at that point. For those of you in the crowd, this is probably the type of thing that I'm not going to be ruling on today, if that's what you came here for. This is a hearing where the parties are going to be talking about legal issues. There's, if you've been on the court website, there's literally hundreds of pages of exhibits that there maybe hundreds, maybe understating it, of exhibits that I have to be referred to and will be referred to and talk and looking at that I've tried to review as much as possible. But I think the arguments will focus me on some of those as well. I just want to make sure people are aware of that as we get started today. I will ask everybody not to talk or interrupt. If you need to get up and leave, please do so as quietly as possible. I guess if that's where we're at, Mr. Zavalos, are you going to go first?
I am.
All right.
Thank you, sir.
This is on behalf of the plaintiff. Go ahead, sir.
Your Honor, I'm not going to go over the entire case for obvious reasons. It's briefly.
Let me ask a question. Can people hear Mr. Zavalos? We could get a mic closer to him if that's. I just want to make sure anybody on Zoom can hear him as well. Can you hear him, Ms. Daneman?
No, Your Honor, we cannot hear very well.
Yeah, the people here in the courtroom should be able to hear him, I'm hoping, but I was worried about so get the microphone closer to Mr. Zavalos.
I cannot hear him either, Your Honor.
Thank you. I guess I'm going to remind everybody we have a court reporter, so if you speak, make sure I hear your name. That was Mr. Morgan.
Can you get up closer?
Like that.
If that'll work, does that work, Your Honor?
That works better, yes.
Do the other participants on video, can they hear me?
Yes, thank you.
All right.
And that's the best we can do anyway. So go ahead, Mr. Zavalos.
Well, thank you, Your Honor. And again, as I was mentioning, I'm not going to argue the entire case at all. I'm going to be very brief. It's just a sketch of an outline of where we're going and some comments and things for the court to be aware of. Ms. Jennifer Wright will really give the sum and substance of the new evidence and the information we have that leads us to believe that not only the newly discovered evidence, but the entire situation that took place is such that this court has a basis in fact and a basis in law to get it right and to grant the motion for a new trial. We're here because one of the contestants, Abraham, wants a recount of certain matters, limited in scope. It's not to ask for the entire state to have a new election. And I would only posit by giving just a few comments before I get started about how significant the event is here today, because it was one of our founding fathers, Thomas Jefferson, who opined, as he did on many things he wrote, that when talking about voting, he made this comment: we do not have a government by the majority, we have a government by the majority who vote. And in my younger years, I had the privilege of seeing that plaque at the Justice Department, where I was an attorney there. in a special litigation unit that handled both criminal and civil matters and also handled voting rights litigation. And one of a late colleague of mine, but many, many years ago, under that beautiful plaque of Thomas Jefferson in the voting rights section, had this: we do not have government by the majority. We have government by the majority who vote, and those whose lawful votes are counted. And
Not
that
going to have any amens during the hearing. It's not appropriate, doesn't help. All right, if you can't be quiet, please leave. All right, thank you, Mr. Go ahead.
and that is consistent with even our court in Griffin versus Bizarre, when it said we need the doors open to hearings, to hear challenges. I think all of our courts understand that. And it's in part what our founding fathers gave us, and it's in part what people have fought for in this country over the last 2 centuries and died for. So this is a solemn occasion, and I tip my hat to the lawyers on both sides, because what we do here matters. It's solemn, and it's just one step from a temple as far as we are concerned. On December 23rd, 2022, the court presided over a contest where the only time Mr. Hamadeh had was limited to viewing essentially sample ballots in Maricopa County. The upshot of that challenge was not successful. There were some issues, and I'll let my colleague talk about what those issues were about, but they didn't rise, at least at that stage, to the level of new evidence, to the level this court needs, because effectively we learned that Ms. Hobbs came to this court through her counsel and basically argued that Mr. Hamadeh did not have any evidence. No evidence. Because there's no evidence, please place the winner in the hands of the current person who is sitting, Ms. Mayes, as Attorney General. Unknown to this court, and this is only one small aspect because the case isn't about fraud. It's about new evidence and it's about facts. But it's important that I bring this up, and I believe Ms. Wright's going to bring it up because it matters. Because inferences are drawn. Inferences are drawn in civil cases and criminal cases when public officials either act with reckless disregard for the facts that matter or actually suppress them. And in this case, not that the suppression that took place, whether willful or not, would necessarily have changed the outcome. And this is just a very small portion of what we're going to deal with today. But it deprived the court and deprived everyone else of asking questions. And we believe the current governor, when she was acting in a prior capacity, knew that there were a number of votes, approximately 63 votes concealed from Pinal County. And when she asked for the new person to hold the office of Attorney General, either she or others in her capacity or representing her knew or should have known, or she engaged in blind ignorance of the fact that there was, in fact, valid votes that would have at least caused this court, perhaps, or counsel to give some thought to what is that about, and does it materially matter? That is something that my colleague will talk a little bit more about. But I will tell you, in the 43 years of litigation that I've been involved in the jurisdictions which I practice, and too many in Pro Hoc Vici, that when evidence or information is not revealed, it does violence to the interest of justice. It does violence to the truth function of a court and of parties. And it is something at the very end I want to talk to this court about, because there is an instruction in this state and before the Ninth Circuit about deliberate ignorance and what that means, and whether a court can draw inferences from that, in which we contend it certainly can, because it was highly inappropriate that it took place. That will be a matter my colleague will talk about, and we won't dwell too much more on it than that. But it did involve undervotes. and they matter. What we do have, and what does in fact specifically and absolutely requires, what new evidence do you have that may likely lead or believe this court to believe that our client, Mr. Hamadeh, actually won the election? We believe the evidence we have today, and I'm just going to briefly go through it, and I want the court to understand the perspective, because another court, no matter what's going to review this. But I want the court to understand that when it deals with evidence before it, when we come before this court for a new trial, and we were handicapped at the beginning stage by either deliberate or inappropriate behavior or simply mistaken behavior, perhaps, that deprived us of being able to do our due diligence and perhaps giving the court an opportunity to give us a little more time. Had I been here, I would have asked the judge, Your Honor, at this time, we need to have this hearing back to get a little time to examine a little bit more about this, rather than asking you, Your Honor, to sit there and make a deliberate judgment. I wasn't here. I think that should have happened, but it matters now because it gives this court an inference about circumstantial evidence and whether we can draw inferences, as courts do every day in criminal cases. When somebody takes the Fifth Amendment, an inference is drawn in a deposition or in a criminal case. When somebody withholds evidence, and it's up to the court to decide whether it was just oblivious mistake or whether there was blind ignorance, if not willful, deliberate effort, it's up to the court to decide that and to give it whatever weight it decides it thinks is appropriate, if any. But we did discover undercounts, and we're going to go into a little detail about that because you need a record before you to get your hands around this case, Your Honor, and to get it right one way or the other. We had a recount totals more than 76,339 votes recorded as undervotes in the Attorney General's contest. That's a significant amount of votes. And they're significant, but they have to be measured against what? There were approximately 2,000 votes so far, ballots inspected. 14 votes not tabulated for the AG's race, or 0.61, were misread. If misread is consistent statewide, and we don't know, but it may have been. There are 466 or more uncounted votes in the AG race, which we believe would have gone to Mr. Hamadeh, that exceeds the 280 vote margin between the vote findings just past November. These were limited to Maricopa. And Maricopa is not the only jurisdiction that we need to look at. As my colleague will tell you, we need to do a sample and find out what actually happened. Those are a lot of votes. They're a small percentage, but in a case where 280 some votes are the difference, that matters. And it matters because our votes, as Jefferson told us, matter. They need to be counted. And forgive me for digressing a minute, but it was my old office before I became a U.S. attorney many years ago as a federal prosecutor in Houston, in Washington, where men and women that were a little older than me at the time were fighting not just for the right to vote, but the right for voters who did vote to have their votes counted. And sadly, that some of that was in the South. So this is important. And we have a lot of undervotes that matter, that could absolutely, and we believe, turn the election in favor of our client. We believe it's reasonably likely that that is what happened. But this court can't make that finding. It can only draw an inference to see whether we met that threshold for the court to say, it's very possible, if not likely, this man won, but I can't make that decision until I allow a new hearing and I attest what I do as a judge, the evidence, by the rules of evidence under Arizona law, and by my understanding and my weight as a judge to this. And there's another area called provisional ballots. We believe the provisional ballots that were lost and never counted likely would have turned in favor of Mr. Hamadeh, and that alone would have turned the election in favor of our client. And we don't come today with hyperbole or speculation, because that isn't the stuff that gives this court grounds to grant the motion. We come with some reasonably solid evidence, and we need a heck of a lot more for this judge and this court to get its hands around and make that final decision. What happened with provisional ballots, Ms. Wright will tell you, but a lot of them dealt with new voters. You had in Maricopa County a number of votes rejected from people who had signed and not just Maricopa County, other jurisdictions that had voted in 2018, 2020, and many in 2022. And their votes were rejected. Well, in more detail, and I think it's important for the court to get its arms around this, because this is a case where there's a mechanical mistake, errors by our state, because our state isn't perfect. No state is, not even Florida or Texas, but it's growing. And what happened in part was we had ballots that weren't counted, that were signed, people who had moved to different jurisdictions, people who had one property and another property, and they voted and tried to vote. And in fact, we found that there were substantial votes that were not counted. And the percentages of those votes are important for the court to hear today. The system and the problems dealing with Service Arizona Voter Information Database are things that this court ought to consider. I think if I said anything further, I would be going into the merits and the sum and substance of what Ms. Jennifer Wright is going to talk to you about. But I would like to be able, with this court's indulgence and permission, a few moments at the very end, if it becomes necessary, to wrap it up.
Talk about in response.
Yes.
Yeah, you guys will have a chance to respond.
I would now turn it over to my colleague.
Right.
Ms. Wright.
Right, go ahead, Ms. Wright.
Thank you, Your
Do you
Honor.
want this?
Yeah, I do.
Okay.
Just, can you put the quad views? Can you guys see the attorneys in the courtroom from there, or just see me? I think. Let's do this.
No, Your Honor, we cannot.
This will be better. There you go.
Okay. All right. Thank you, Your Honor. This afternoon, I'm going to address the legal standards for granting a motion for new trial and the newly discovered evidence. I'm going to start first with the newly discovered evidence and why we believe that this evidence will prove that Abe Hamadeh and not KRIS Mayes received the most votes for Attorney General, and as required by Arizona's Constitution, should be declared elected as Arizona's Attorney General. After I've discussed the new evidence, I'm going to discuss the relevant legal standards and case law that supports our motion. Now, I know that contestee in this case and defendants have tried to confuse these issues, but we're here today for a few simple reasons. First, on December 23rd, Your Honor presided over Abe Hamadeh's election contest. The evidence presented at trial was virtually solely limited to reviewing the sample of ballots inspected in Maricopa County. If you recall, ballots that were recorded as having no vote in the Attorney General's race were reviewed. And Maricopa County Elections Director Scott Jarrett testified over and over again that he did not know why certain votes were not counted and instead recorded as undervotes. And as a refresher, an undervote means that no vote was recorded as cast for either candidate for Attorney General. At trial, all parties agreed that there were marks on ballots that evidenced the intent of the voter to have cast a valid vote in the Attorney General's race. And based on the findings, Abe Hamadeh, through co-counsel Tim Lasota, renewed his request for an expanded review of ballots and specifically renewed his motion for expedited discovery. And if you remember, on December 22nd, the day before trial, the issue of ballot inspection was addressed in an emergency hearing. Both times, Mr. Lasota asked for more time to inspect more ballots that were recorded as undervotes. But surprisingly, at the December 23rd evidentiary hearing, then Secretary Hobbs, who should be a neutral, nominal party to an election contest. In fact, Your Honor, the election contest statutes do not even require the Secretary to be a party to the case. I think that over time that the government bodies that have control over evidence in election-related cases have been made parties solely for the purpose of following the orders of this court, but I digress. Then Secretary Hobbs, through her counsel, argued at the hearing that Mr. Hamady, quote, had no evidence to support his claims and asked for, quote, prompt dismissal of this case, and asked this court to confirm, quote, Attorney General-elect Mayes as Attorney General. However, at that very moment, Hobbs had evidence from Pinal County that at least 63 votes that were originally recorded as undervotes in the Attorney General race had been determined to be valid votes that were eventually added to the canvass in the recount. Hobbs and her counsel knew at that moment that the evidence she said Mr. Hamady didn't have, that issues raised at trial regarding machine tabulators misreading valid votes as undervotes was not speculative and not limited to just Maricopa County. She was told this in a report that was provided to her on December 21st. And in fact, recent media reports suggest that Hobbs may have even known as early as December 7th, several days before this contest was even filed. Hobbs and her successor have argued that Maricopa County Superior Court ordered her not to disclose that information, but that's not true. As we've argued in our briefs, the recount order only prevented counties from discussing the recount results or vote totals. The secretary was under no order preventing her from informing this court and Mr. Hamady that there may be an issue with undervotes that suggested further inspection of ballots might be warranted. She knowingly withheld this information. Instead, her counsel argued that Mr. Hamady had, again, quote, no evidence, and urged this court to confirm Mayes. Frankly, Your Honor, I find it a bit questionable that a government agent would take a position in support of or in opposition to a candidate in an election contest. But again, I digress. So reason number one for the new trial, then Secretary Hobbs intentionally withheld information only known to her that confirmed that precise issue at trial was not speculative, but was in fact a source of significant vote swing in Pinal County. And Your Honor, I think if then Secretary Hobbs had been forthright, you may have granted Mr. Hamady's request to inspect more ballots before this court made a final determination in this issue of great significance to the people of Arizona, who actually received the most votes. Arizona's Constitution demands that the person with the most votes be declared elected. We are here today to give that constitutional provision meaning and ensure the will of the voters of Arizona is achieved. And I'll talk a few minutes about what the evidence shows about undervotes statewide. But first, let's discuss the second reason we're here today. And why was this resolved in December like it should have been? In Mr. Hamady's motion for expedited discovery, he specifically requested the list of persons who cast a provisional ballot that was not tabulated. This request was reasonably calculated to narrow the scope of provisional ballots that were available for inspection under 16-677. Simultaneous with this discovery request, a public records request was made. Although this court did deny the request for expedited discovery, the information requested was a public record that was readily accessible electronically through the computers or county's computer systems in a report no later than the date of the canvass. But this information was not obtainable by Mr. Hamady through any other means other than making a request to this court and through public records laws. Mr. Hamady exercised due diligence to obtain those documents, but Maricopa failed to provide them until after trial. In fact, the request was fulfilled on Saturday, December 31st, 8 days after trial. And whatever the reason, and I honestly know that the county had simultaneous litigation and a large number of public records requests to process at that time. But regardless, Maricopa did not provide those records until after trial, and Mr. Hamady could not have obtained those records through any other means. Mr. Hamady exercised due diligence, and despite his best efforts, those records were not provided by the sole possessor of that information until after trial. And we are here today for the simple fact that then Secretary Hobbs secreted information that confirmed tabulators were recording discernible votes in the Attorney General's race as undervotes. Information that may have led this court to expand the ballot inspection. Further, we are here because Maricopa did not provide provisional ballot information until after trial. Information that, had it been timely provided, we would have been able to address those problems we found at trial. Based on what we now know, information Mr. Hamadeh could not have known at the last trial despite his due diligence, this court would have ruled differently, and the evidence would have been proven Mr. Hamadeh received the most votes and is the democratically and constitutionally elected Attorney General. Now let's discuss what the newly discovered evidence shows. I'm going to have a couple of demonstratives. I have them available to the court if we wanted to do them. I do have them on a poster. These are just, these aren't evidence. These are just visual aids. Just to give you, and most of the stuff is already in our pleadings, so this isn't new information. I will say the one part about this is the statewide undervote. In our pleadings, we had most of the counties based off of the official reports of undervotes. So what we now have is we went through and added in the counties and we assumed what their undervotes probably were for some of them based off of the number of total votes cast in that election versus total votes cast in the Attorney General's race.
Yeah, approach to give.
Your Honor, we cannot see that demonstrative. We haven't been provided it. We object to the court considering it. This is not an evidentiary hearing.
I'm gonna let them argue their case. This is a motion for new trial, and obviously, if we could get these documents to these parties through email or something, that would be beneficial. So if you get copies of these documents to everybody that's requesting them, this is just an exhibit they're making, and this is a motion for new trial. I want you to see it, and you have a right to see it, but it's not being admitted as evidence. So go ahead.
It's not, no. And Your Honor, most of this is already in our reply to our motion for a new trial, in support of our motion for new trial. We have this chart within it. We just expanded it to include counties that did not report their official undervote, and we're making.
Your Honor, for the record, I'm sorry, I couldn't hit you. The Secretary of State joins in Ms. Danneman's objection. Thanks.
Yeah, I'm taking everybody's objection to this document. I'm allowing her to argue it in this motion, oral argument for motion for new trial.
Right.
And hopefully, Mr. Morgan, you among everyone else are getting copies of this as we speak. I see one of the attorneys doing it on his phone. I don't know how they do it on your phone, but that's what's happening. All right. So hopefully you'll get that relatively soon. But again, it's in some of the stuff, and I remember seeing these numbers. Some of the stuff I've already read, you'll be familiar with, and you'll get a copy of it. So go ahead, Ms. Wright.
All right, so first regarding the undervotes, based off of the official canvases of each county, and this is based off of on the recount totals in this last column, there are upwards to 76,339 votes recorded as undervotes in the Attorney General's race statewide. Evidence from the trial suggested that of the 2,000 or so ballots inspected, 14 votes had votes that were not tabulated in the Attorney General's race. That equates, and I put this, that's in our pleadings, about a 0.61% misread rate. Now, assuming that same misread rate is consistent statewide, we believe that there may be 466 or more uncounted votes in the Attorney General's race, and that well exceeds the now 280 vote margin that separates Ms. Mays and Mr. Hamadeh. Based off the newly discovered information that undervotes impacted more than just Maricopa County and to such a degree that it would likely change the outcome of the election, Mr. Hamadeh should be afforded the opportunity to inspect all 76,000 undervoted ballots, which will be well within his rights under 16-677, which states that either party may have the ballots inspected. Now, contrary to contestees' mischaracterization, Mr. Hamadeh does not request to review more than 2.5 million ballots. Rather, just the ballots that have been recorded as an undervote in the Attorney General's race. And I assure you, Your Honor, that as we get closer to issuing those orders, we can show that it's a matter of public record that ES&S, Dominion, and Unison tabulators, which are the three systems authorized for use in Arizona, according to the Secretary of State's website, all take electronic images of each ballot. And based off of the cast vote record, CVR, which was discussed in great detail during the emergency hearing on December 22nd, the electronic images can actually be filtered to show just ballots with undervotes in the Attorney General's race. So We are only going to be asking to review a subset of ballots that should be able to be sorted, obtained, and reviewed, mostly electronically. For undervotes, we're not going to be able to predict how the vote margin will change, but as Mr. Hamadeh has asserted, every vote should count. This is particularly true when votes are not being recorded because the machines cannot accurately interpret voter intent. Critically, we are not asking this court to predict or apportion votes on any statistical theories. Rather, we are asking the court to count and determine with mathematical certainty the number of votes cast in the Attorney General's race based on reviewing not just clear and convincing evidence, but the best evidence, the ballots themselves. Second, provisional ballots. Here we have a very good sense of how these ballots will shake out, and the evidence we have now suggests that once certain provisional ballots are counted, the provisional ballots alone will prove that Abe Hamadeh received the most votes for Attorney General and is the democratically and constitutionally elected Attorney General for the state of Arizona. Critically, Your Honor, if granted a new trial, the evidence that Abe Hamadeh won, again, will be the ballots themselves. I'm going to get into some data here that represents the evidence we have found that suggests once certain provisional ballots are counted, the outcome of this case and the results of the Attorney General's race will be that Abe Hamadeh is Arizona's Attorney General. But ultimately, this case does not and will not rely on adding or subtracting theoretical or speculative votes. Rather, this case will count the undervotes and will count the erroneously rejected provisional ballots, giving us a sum certain of who actually received the most votes for Attorney General. And at the conclusion of the new trial, the outcome of the Attorney General's race will be known with mathematical certainty. Now, regarding the data related to erroneously rejected provisional ballots, let's dig into that a bit. First, after our review of the rejected provisional ballots from Maricopa County, we almost immediately found that hundreds of Maricopa County voters had a very unusual profile. Now, ordinarily, provisional ballots are cast by first-time Arizona voters. They're either too new to the state or due to age, this is the first time they've ever voted. These voters don't know that you have to register almost a month before the election, and they show up to vote on election day and are ineligible. What we found in the list of rejected provisional ballots data was that hundreds of the thousands of rejected votes were cast by people with significant voting history. People who voted in 2018, 2020, and even some of them voted in the 2022 primary. But nonetheless, the provisional ballot was rejected, and not, for instance, for having already cast an early ballot or failing to present ID or even forgetting to sign the provisional ballot, but for not being registered to vote at all in Maricopa, which seemed odd. Why would a voter show up on election day to cast a ballot? A voter who has successfully voted, some as recently as August of 22, at a voting location in Maricopa where they've always voted, and have their provisional ballot be rejected for not being registered to vote in Maricopa. It just didn't make sense. After looking at the other counties, we found more similarly situated voters who had recent active voting histories that had rejected provisional ballots. In fact, so far, we've identified about 1,100 voters that fit this profile. More than I should say. And after interviewing hundreds of those voters, we found that many are voters who have connections to properties outside of their home county, and due to no fault of their own, but instead changes to statewide computer systems, their registration was moved from their county of residence to the county where they have some connection without the voter's express knowledge, consent, or intent in a way that lacks the requisite procedural due process requirements necessitated before depriving someone of their sacred right to vote. At trial, we can get into the specific details of how, when, and why we think these voter registrations were computer systematically removed. But for the purposes of this motion, I think it suffice to say that it appears that more than 1,100 election day provisional voters were, we believe, wrongfully disenfranchised. This right here, we have hundreds of declarations we've obtained from voters, hundreds. These are all people that tried to vote on election day and had their ballot rejected They were told they were not registered to vote. Turns out, with many of these declarations, we have their voting record and history, and we can see when and how it was changed, and it was not by their own intent. And we know their intent because they didn't even show up to vote in the secondary county that was assigned to them. So if they had intended to move to, say, Navajo County, then why did they show up to vote in Maricopa? Hundreds. Instead, they cast one vote. There's no record of them casting more than one vote. One vote in their home county that was ultimately rejected and is currently waiting to be counted. Your Honor, you have the power to order those votes to be counted. What we know is that statewide election day votes overwhelmingly were for Abe Hamadeh. Assuming, and this is another demonstrative, I think it's already been emailed now.
I'm sorry. That's right.
This is just a demonstrative.
May I approach the row, Your Honor?
Sure.
What we know is that statewide election day votes overwhelming were for Abe, assuming that the 1,100 voters that have rejected provisional votes, and those are election day voters, voted consistently with the statewide canvass. Abe Hamadeh received 69.21% of election day votes, and KRIS Mayes received 28.72%. You can see 2% is other. That would suggest that of those 1,100 provisional voters, 761 of them would be provisional ballots for Abe Hamadeh, and 316 would be provisional ballots for Mayes. On that fact alone, if we subtract Hamadeh's total from Mayes' total, we get a net increase of 445 Hamadeh votes. Subtract that net increase from the current vote margin of 280 votes. This data suggests that Mr. Hamadeh on the provisional issue alone should prevail over Ms. Mays, by 165 votes, making Abe Hamadeh the democratically and constitutionally elected Attorney General for the state of Arizona. At this point, we have evidence that the government systems and procedures failed to meet the constitutional procedural due process requirements necessary to prevent erroneous disenfranchisement. And to be clear, we are not alleging that these voters had their voter registrations intentionally canceled or moved to some sort of nefarious plot. Instead, we believe that good intended changes were made to both Service Arizona and the Arizona Voter Information Database that unintentionally and tragically caused the disenfranchisement of hundreds of Arizona voters. We also have evidence that other issues, such as improper instructions at precinct-based voting locations, caused voters to be disenfranchised. And I believe we have a declarant in our materials that we provided, Your Honor, in our reply of some voters in Mohave that received some erroneous precinct-based instructions. And just to be clear, the election contest statutes do not require that we allege fraud or intentional misconduct. Instead, we assert, by reason of erroneous vote counts, Ms. Mays, who was declared elected, did not, in fact, receive the highest number of votes for office of Attorney General. Now I'm going to get into the legal standard and relevant case law. Mr. Hamadeh timely filed for a new trial under the Arizona Rules of Civil Procedure Rule 59, including by reason of irregularities in proceedings, errors of law, and newly discovered material. Specifically, Rule 59 provides that a new trial may be granted when there is newly discovered material evidence that could not have been discovered and produced at trial with reasonable diligence, which materially affected, in this case, the plaintiff's rights. So frankly, I spent almost the last 20 minutes discussing what material was discovered, how it will change the outcome, and detailed why it could not have been produced at trial, despite plaintiff's reasonable diligence. In fact, the evidence itself was under lock and key by the government bodies. Frankly, Your Honor, this trial should be granted for no other reason than to encourage government bodies to be forthright with information and be quick to provide the requested materials. But again, I digress. Because defendants are anxious to prevent a new trial, they have crafted some clever legal arguments that fail under existing precedent. Arizona's highest court has time and again found that the rules of civil procedure apply to election contests. In fact, Arizona's Constitution gives the judiciary the sole authority to dictate court procedures. And the legislature is without authority to abrogate the constitutional authority of the judiciary. And I dare say, you don't want to give the legislature any ideas, as I'm sure they would likely be more than happy to meddle with the rules of civil procedure in other contexts to advance other important policy objectives. But this court need not make any presumptions about the role of the rules of civil procedure, because we can look to Griffin v. Buzzard. That granted a motion to dismiss despite a specific statutory requirement that the court shall continue in session to hear and determine all issues arising in contested elections. More recently, a Maricopa court held an election contest arising out of the 2022 Secretary of State race that the rules of procedure apply in all civil actions and proceedings in the Superior Court. And a contest is such a proceeding. And the Arizona Supreme Court just remanded an issue back to Maricopa County Superior Court in a contest arising out of the 2022 governor's race, which, as of last night, is headed for trial tomorrow. In fact, in yesterday's order, which we can provide a notice of supplemental authority for, the Maricopa County Superior Court, in declining the merits, let me go back. The Maricopa County Court, in declining on the merits, the plaintiff's Rule 60 motion for relief for judgment, the court noted that to the extent that the civil rules can apply without contradiction to an election challenge, they do apply, adding that includes Rule 60, and suggested, maybe foolishly, given the constitutional authority of the Supreme Court, that the legislature could have abrogated or accelerated the rules of an election challenge to preclude Rule 60, or here Rule 59, and if they had so desired. In regards to the time elements of election contest statutes, Arizona's highest court has already determined in Brusso v. Fitzgerald that the time elements of the election contest statutes are necessary, arbitrary and jurisdictional as it relates to when the contestant must be filed, when the contest must be filed, but it's directory and really an expression of policy preferences and guidance to the court as to when the court must hold the trial. And I'd also note again, it says in the statutes that the court shall hear all the issues, and it doesn't have a deadline as to how long that might take. It's an open-ended period. It just says that once you make a ruling, you have 5 days to order it and deal with whatever election certificates of election issues might arise. In regard to mootness and other issues raised by defendants, although defendants understandably want to wish away Hunt v. Campbell, it is the preeminent case regarding election contests. In one of the first gubernatorial elections after Arizona became a state, the incumbent governor, Mr. Hunt, filed an election contest that ensued for 13 months. And as a side, this statehood era case highlights that the legitimacy of elections has been questioned time and again. Frankly, what is old is new again. And that's why Arizona statutorily provided for election contests, to allow the judicial process to examine, question, and correct elections, especially ones that are so very close and where the questions linger about the legitimacy of the results. The judicial process is key to restoring waning confidence in election administration. Going back to Hunt v. Campbell, after scrupulous review of the ballots and 13 months of litigation, Arizona's highest court declared elected Mr. Hunt, and Mr. Campbell, who had been sitting in the governor's office for an entire year, had his certificate of election declared void and of no effect, and was hereby canceled and annulled. Fun fact, Arizona's gubernatorial term was just 2 years at that time. So in 1918, right after he won his election contest, Mr. Hunt chose actually not to run for re-election, so he was going right into an election cycle. Mr. Campbell, who had just lost the election contest, ran again and beat out a Mr. Coulter by 0.61% of the vote. Campbell served 2 terms before facing off again to Mr. Hunt in 1922. And then at that point, Campbell lost in a landslide. From the days of Nero to the pages of the New York Times, politics has always been regarded as somewhat of a blood sport, with people wanting power or wanting to remain at power at virtually any cost. And elections have been questioned since the dawn of time and will continue to be questioned. The 1916 and 1917 Arizona Supreme Court respected the judicial process to resolve, I quote, the most important question affecting the purity of the elections and the legally expressed will of the voters. More than 40 years later, in Griffin v. Buzzard, the Supreme Court made clear Arizona courts must be alert to preserving the purity of elections, and its doors must not be closed to hearing charges. And while that case had allegations of fraud, the sentiment remains the same when erroneous government processes have disenfranchised what appears to be more than 1,000 voters. And tabulators apparently failed to read hundreds of votes. This court, too, should ensure the outcome of the Attorney General's race is, in fact, the legally expressed will of the voter, and Arizona's Constitution demands it. Although the election was 6 months ago, I'd note the High Court took 13 months to fully litigate, and the Reyes Court, another successful election contest, and that one from 1997, was not fully resolved until the Arizona Supreme Court declined review in March of 1998, full 16 months after the election. We are not outside the norms of these delicate, complicated, important proceedings. And many of the courts, even one raised the mootness issue because it was a primary election. And Your Honor, Bond sitting down, I get the court case name, which one it precisely was. But it was a primary election which the issues had already been resolved, and the court continued after the general election to hear the contest because it is important to get it right. Arizona's judicial system strives to get it right. Your Honor, I humbly urge this court to grant our motion for a new trial to ensure in a race separated by only 280 votes out of more than 2.5 million votes cast, that the legally expressed will of the voters is achieved and the democratically and constitutionally elected Attorney General is in fact declared elected. Your Honor, simply put, we're asking you to give us an opportunity to prove to you that you should count the discarded votes. Thank you.
Thank you, Mr. Wright. Ms. Danneman, you're going to go first. I see you standing. You have to unmute. There you go.
Yes, Your Honor, thank you. Plaintiffs just spent most of their argument urging this court to consider various so-called facts, most of which are just unsworn speculation and opinions and testimony of their counsel, not actual evidence. And plaintiffs seek their extraordinary relief under the guise of a new trial motion. But they ignore the fact that election contests are limited statutory proceedings designed to resolve cases on short timelines in recognition of the strong public interest in the finality of elections. To allow a new trial motion more than 6 months after an election and nearly 5 months after a full trial would directly conflict with the contest statutes. But even if such a motion were allowed, plaintiffs fall far short of the proof necessary for such an extraordinary remedy. As plaintiffs readily admit, as we stand here today, more than 5 months after the trial, they still are not in possession of actual evidence that would change the results. Instead, their argument before this court boils down to the election was close. If you let us keep looking, we might find something. But as they said in their papers, quote, a more complete ballot inspection is necessary to confirm. And it's consistent with what they've asked for today, Your Honor. They've asked for, quote, a little more time. To sum up, they had no proof when they filed their contest. They had no proof for their claims at trial when plaintiffs admitted stunningly that they did not have enough evidence to, quote, sustain this particular contest. They have no proof now. What this motion really boils down to is not a request for a new trial, but a request for a post-trial, quote, meticulous review of many thousands of ballots, quote, without the rush conditions of a contest to, quote, ensure the accuracy of the election. Plaintiffs admitted that again during their argument before this court. Plaintiffs want their own recount, and they've asked for this court for that expressly today. This relief is unprecedented. It would also conflict with the contest statutes, the recount statutes, and Supreme Court precedent. And I know Your Honor has received a lot of written material in this case, and I don't want to repeat that, but I would like to briefly highlight for the court, especially in light of the argument today, first, why this motion is procedurally inappropriate. Second, why it's meritless. And third, some additional reasons why the relief they're seeking is prohibited. So first, Statutes for expedited election contests do not permit new trials. As this court well knows, election contests are limited and must be conducted in strict conformity with the contest statutes. They have strict timelines. Again, a contest must be brought within 5 days after the canvass. The hearing must be held not later than 10 days thereafter. Then the court must, quote, file its finding within 5 days and then, quote, immediately thereafter pronounce judgment. To allow a new trial now would conflict with, at a minimum, the deadline for setting a hearing, the requirement that findings be entered within 5 days, and that judgment be entered immediately. Arizona courts have not confronted the exact question of whether a new trial motion is permitted in an election contest, but other jurisdictions have and found that such motions are prohibited, like Nebraska and California. And the Supreme Court has specifically rejected attempts to apply rules of procedure that are inconsistent with the contest statutes, like Rule 59 is here. For instance, in Grounds v. Law, the court recognized that you couldn't amend your contest statement after the deadline for filing. Simply put, to grant a new trial would conflict with numerous statutory provisions by allowing plaintiffs, in essence, to start from the beginning of the contest. Before the court today, plaintiffs seem to suggest to the court that we believe that the rules of civil procedure do not apply in election contests. We've never said that. Of course, certain civil procedure rules apply in election contests, but not Rule 59 because it directly conflicts with the contest statutes. And plaintiffs put too much weight in their papers and before the court today on Hunt v. Campbell. When Hunt was decided, there were no expedited timelines for elections. As set forth in our papers, the only deadlines were for initiating the contest and answering the contest. And the statute provided that the court had discretion to set and, quote, continue the time of the hearing. In contrast, today, as this court knows very well, statutes here set short deadlines for initiating a contest, hearing a contest, and deciding a contest. But even if the court could consider the motion, plaintiffs' claims fail on the merits. And I think it's worth pausing here. The court heard a lot of testimony by counsel today. But when you look at the actual, quote, facts, and then you look at the rules, plaintiffs' claims fail. And in their motions, they nowhere engage in any analysis as to why, based on the specific provision of the rules applied to specific facts, they're entitled to a new trial, which is an extraordinary remedy. Between their motion and reply, they cannot even consistently identify the claimed grounds for a new trial. This should be the end. But I'd like to briefly address in turn each of plaintiffs' claimed grounds under Rule 59. They claim irregularities in the proceedings, they claim errors of law, and they identify, quote, newly discovered evidence. First, irregularities. Plaintiffs don't actually identify any error that occurred in the original trial, let alone one that affected its outcome. Again, plaintiffs finished their case in chief in under 20 minutes, and plaintiffs' counsel announced on the record that the evidence they had was, quote, not enough to sustain the contest. Second, plaintiffs point to errors of law by this court. Though their motion doesn't identify what specific legal errors they're talking about, the reply does. These arguments, of course, are waived. They're difficult to follow, but they're meritless nonetheless. In reply, plaintiffs argue three things. First, the court abused its discretion by denying plaintiffs' request to postpone the hearing. The court followed the law in setting the hearing. By the plain terms of 16676, the court could not have extended the hearing beyond what it did. But in any event, plaintiffs don't even claim an error of law by the court. They claim that the court, quote, abused its discretion. Even if that were true, that's not grounds for a new trial. Next, they try to argue that this court erred by holding that provisional ballots are not ballots contemplated under the law. The court never made such a ruling and never denied any request to look at provisional ballots themselves. Finally, the reply makes a vague reference to the error by the court in, quote, finding that plaintiffs were not entitled to inspect more ballots after it was determined that the tabulators failed. Plaintiffs do not identify the ruling at issue, let alone the error of law related to it. Finally, plaintiffs' last ground for a new trial is newly discovered evidence, and this is really what plaintiffs seem to be focusing on. But despite spending the bulk of their briefing and time before this court discussing various facts, plaintiffs only point to two grounds for a new trial based on newly discovered evidence. And even then, in their papers and today, they fail to engage in any way with the standards for granting this extraordinary remedy. First, the evidence must be material. Second, it must have existed at the time of the trial. Third, it could not have been discovered with reasonable diligence. And fourth, it would probably change the result. When these standards are carefully applied to each fact offered by plaintiffs and through the testimony of their counsel, their motion crumbles. Again, even sitting here today, even before the court today, plaintiffs still cannot point to any fact or piece of evidence that would probably change the result. They admit, quote, that a more complete ballot inspection is necessary to confirm. And before the court today, they ask that the court let them have another look around to confirm. For this reason alone, the motion based on newly discovered evidence fails. That the motion fails is doubly clear by looking at each quote fact in isolation. And there are two of them, again, Your Honor. First, plaintiffs point to the fact that certain ballots in Pinal County were not subject to adjudication on election day, but were subsequently counted during the recount. That's the claim they make most clearly in their reply. This information would not have changed the result of the trial. Plaintiff admits that in their papers, and they admitted that today before this court. They claim at most that this knowledge could have strengthened their request for new discovery. But that's not even true. Prior to trial, plaintiffs also put other similar evidence in their motion papers. For instance, in their motion for ballot inspection filed on December 12th at paragraph 17, they cited evidence from Navajo County that the tabulators used during the statewide recount, quote, identified 2 ballots that should have been sent to adjudication, but were not. Having more of the same evidence would not have changed the course of discovery, nor would it have changed the outcome of the trial. And before this court today, plaintiffs make much of the fact that of their allegation that the secretary knew this prior to trial. But it's worth emphasizing that this is the only evidence plaintiffs now claim was, quote, wrongly withheld by the secretary. But again, none of this information is material and it wasn't wrongly withheld. Under the recount order, the counties are required to report the results to the secretary. The secretary would provide the result to the court, and then the court was required to announce the results. So the second issue for newly discovered evidence is provisional voters. And this claim is quite narrow, despite the testimony of their counsel today. Plaintiffs claim that the list of provisional voters they now have from Maricopa County, and only Maricopa County, entitles them to a new trial. It doesn't. As a threshold matter, this list could have been discovered much sooner with appropriate diligence. At a bare minimum, plaintiffs knew they needed this list when they filed their original contest on November 22nd. And certainly by November 9th, when they filed their contest before this court. The list until December 12th. As this court well knows, days matter in election contests. These timeframes are very quick. In any event, this list of names proves nothing. It will not probably change the result of the trial, which is the actual standard for a Rule 59 motion. Plaintiffs have submitted no actual evidence that these registrations were inappropriately canceled, and they have admitted that they don't know why some of these registrations are canceled. They would have to do more investigation. And still, to this day, they have not pointed to a single vote from Maricopa County, a single voter who couldn't vote. Plaintiffs before the court today and in their papers and their reply attached 2 declarations from Mohave County. Your Honor, plaintiffs' election contest, count 2, talked about the wrongful exclusion of provisional voters in Maricopa County only. Evidence related to what happened to provisional ballots in Mohave County is simply not relevant to a claim in the contest. So in the end, Your Honor, they've admitted that even with this list, they still need to do additional investigation to confirm. The last point I'd like to highlight for Your Honor on the newly discovered evidence claim is that their reply makes clear that plaintiffs aren't basing their motion on many of the things they originally asserted, including testimony from the Kerry Lake case, the results of the hand count, the fact that there was a smaller margin alone, and other issues in Pinal County, including ballots found during the recount. In the end, it makes sense that plaintiffs barely engage with the standards governing new trial motions. They can't meet the rule's strict requirements for this extraordinary remedy. Again, plaintiffs had a trial. They had an opportunity to put on their case. But this motion isn't about getting a new trial. It's about getting any evidence to support their existing claims, and apparently some new ones, something not permitted through a new trial motion, even if it were successful. While plaintiff's original motion is not clear, their reply makes clear that they want three things, and they've testified about some of them before the court today. One is apparently approximately 73,000 ballots. They would like to do their own hand recount on those, and those are ballots with an undervote in the AG case in all 15 counties. Second, they ask for provisional ballots in all counties that officials rejected on the grounds that the voter wasn't registered to vote if they had voted in prior races. This is a new request. Plaintiffs made this request to the court before, and it also, relates to facts and allegations that are outside the contest statute that plaintiffs picked, the one that they filed. Third, they make another new request, this one again not made before, not even tied to a claim in the complaint, which is 73 ballots cast by quote high propensity voters rejected for being out of precinct. These requests are not only extraordinary, but prohibited by law. For one thing, there is only one statute that authorizes discovery in election contests. That's ARS 16677, which allows ballot inspection to quote prepare for trial. But plaintiffs aren't looking at ballots to prepare for trial. They are looking for ballots to find any evidence to support their claims. This sort of a fishing expedition has been expressly prohibited by the Supreme Court. That's Grounds v. Law 67 Arizona 176. Further recounts, and today they asked for a recount. Recounts are strictly statutory and can be conducted only as authorized by statute. That's Barrera. And no authority exists in Arizona for an order for a manual recount for an election when requested by a contestant, particularly based on his suspicion and his testimony from counsel that had the recount been conducted differently, it would have been more favorable to him. Plaintiff's request for an ad hoc extra statutory recount must fail. Finally, I would like to touch briefly on the motion for an order reflecting additional rulings of the court, Your Honor. This motion is about revamping the record for appeal. It's not about putting on, quote, an accurate rendition of the proceedings on the record. And for the reasons set forth in our brief, multiple of these issues have either been decided by the court plainly or not decided by the court at all and aren't appropriate for an additional ruling. And with that, Your Honor, I would just like to close by saying the plaintiffs had their day in court. Plaintiffs were here, defendants were here, the court was here. Plaintiffs admitted at their trial that they didn't have enough evidence to sustain their claims, despite having been permitted to review more ballots than in any other contest this cycle. Close elections are not unprecedented in Arizona. The 2016 congressional election, for instance, was separated by just 161 votes. And the legislature designed a process for close election recounts. Here, there was a full statewide recount, which did remedy some errors and identify votes in favor of the contestant. The recount process designed by the legislature as a safeguard worked. The rules do not allow for perpetual do-overs in election cases. The stakes are too high and the need for finality is too important. A hand count of tens of thousands of ballots 6 months after an election, following a contest, then following a statewide recount was not part of the statutory scheme designed by the legislature for this election. As the Supreme Court held in Donahue, a successful challenge months or years after an election would seriously erode the ability of state and local governments. That's true. The extraordinary and unprecedented relief that the plaintiffs are asking for would cause chaos. Chaos for the court, chaos for elections officials, chaos for the Attorney General. Election contests would go on forever as the contestant could continue to look around for more new evidence indefinitely, and if the court had to oversee a full hand recount without rules or guidance from the legislature. And with that, Your Honor, I would ask that you deny the motion for a new trial and enter final judgment immediately as the statute requires.
All right, thank you, Ms. Danman. Mr. Morgan, you next, or?
I am, Your Honor. Thank you. Craig Morgan for the Secretary of State, Adrian Fontes. I generally join in and agree with everything Ms. Danneman said. I'm going to hit a few points if it's okay with the court. First, I want to talk about the aspersions that have been cast against my predecessor and the prior administration. Judge, they did nothing wrong. They did nothing unethical or remotely prejudicial to the contestant's case. Arizona law is clear. The Secretary of State must present recount results to the court, and only the court can announce the results of a recount, ARS 16665. Judge Thomason's order in Maricopa County precluded others from announcing the results of the recount. No records were to be released until that court certified the results. That's paragraph F of his order. It's in the record. And the parties were to keep confidential all information acquired that would disclose an elector's vote. That's paragraph G. The issues discovered in Pinal County during that recount, Your Honor, would have made no difference to this lawsuit. None whatsoever. Judge, Arizonans deserve finality in the 2022 general election. Every day this case exists without a final judgment is another day that the contestee and his friends and his colleagues and his constituents can continue to impugn the validity of our election processes in Arizona, impugn the integrity of those public servants who have dedicated themselves and their professional careers to preserving our democracy for future generations, and cast doubt on the very foundation of our nation, free, full, and fair elections. Arizonans need this action to come to an end, and Arizona's election contest statute mandates that it does so. Now, even assuming everything that the contestee asserts is plausible or even true, it doesn't matter. Judge, we had the luxury of a statutory recount. That process worked, Your Honor. The concerns in Pinal County were identified because of that recount, and the results of this race were verified and validated. KRIS Mayes is our lawfully elected Attorney General. Mr. Hamlin doesn't like that outcome. That's the correct outcome. What the contestee wants here, Your Honor, is extra statutory relief. It's unavailable as a matter of law, and it flies in the face of the narrow and express relief to which he is entitled. Relief that he has availed himself of in this election contest, albeit unsuccessfully. The contestee, Your Honor, he wants to try again. He wants to make his own rules of what an election contest can be. And even after losing in a lawful recount, which he has not challenged or appealed in any way, as far as I'm aware, he wants a second bite at the apple, arguably a third in light of the recount. As someone attempting to seize control of the office of Arizona's chief legal officer, one would think that the contestee would appreciate the irony of asking this court to afford him legal relief that is unprecedented, unavailable as a matter of law, and flies in the face of the rule of law. It's long past time for this case to end, Judge. No new trial, no second recount, no expanded election contest. Please deny Mr. Hamda's motion in our final judgment. Thank you.
Thank you, Mr. Morgan. Mr. LaRue.
Thank you, Your Honor. Maricopa County has nothing to add to the argument that was made by the governor and the Secretary of State.
Thank you, Mr. LaRue. Mr. Gierkowitz.
Just briefly, Your Honor, if I may. So I'm not exactly clear what relief the plaintiffs are requesting, but if there's any further indication that they want to continue inspecting or counting Kima County ballots, we would very much object to that. The court-ordered inspection here was held on December 22nd, and not a single error was found in the results. As far as the court's jurisdiction, I believe ARS 16676 time bars any further contest. And furthermore, we had discussed a long time ago the interplay of the contest statutes and the recount statutes. ARS 16667 stays a recount while a contest is being mounted. And what's the purpose of that statute? Why do we stay the recount while a contest is going forward? Because that is the opportunity to determine the validity of the pled contests. And that's what happened in this particular case. Plaintiffs were given an opportunity to try and prove the allegations they made in their contest. That statewide recount was stayed to give this court the opportunity to determine the results based on this contest. Once that contest was over, however, and this court announced its result, the recount was reinstated and the Maricopa Superior Court announced the final results in the recount for the state. That also divested this court from further jurisdiction to entertain a further contest. The final results were announced. It could not be collaterally attacked in this court. The only path for relief at that point would have been appeal of the Maricopa Superior Court's order to the Court of Appeals. Thank you, Your Honor.
Thank you. Does anybody else wanted to add anything, or
Your Honor.
Mr. Davis?
Your Honor, Mohave County is here only to present our supplement or joinder for the defendant's motion when you feel it timely to argue such.
You're talking about the
Compensation here.
yeah, the compensation. We're not there yet. All right, thank you, Mr. Davis. All right, anybody, the response from the plaintiffs then? And I'm assuming this time it'll be Ms. Wright, followed by Mr. Zavala.
Yes.
I've got that down now. Now, I guess, how long do you think you're going to go? My court reporter is going to need a break whenever we're done. So she's been going for an hour and 20.
Do you want to take a break now, Your Honor? I'm fine with that.
I do want to take 15 minutes. We'll take a break because the court reporter shouldn't go more than an hour and a half. All right, we're going to take a brief recess. I'm going to put everybody on mute. You guys stay there. I'm going to go in the back and hide, or not hide, just go in the back. We'll stand at recess.
Thank you, Your Honor.
So let's go. Yeah, I want to get shanked on there. Well, I'm sure as a former criminal attorney. Yeah.
We're back on the record. We unmuted her. So we're coming out of recess, right? And hopefully everybody's there. Ms. Wright, you guys get to finish the rebuttal. So go ahead.
Your Honor, I want to take us back. So I've mentioned Hunt v. Campbell, but I haven't discussed much as Campbell v. Hunt. Campbell v. Hunt was the case that was brought by the person who had been declared elected at the gubernatorial race in 1916. He wanted to take possession of the governor's office. Of course, he had been declared elected. He had his certificate of election. And in fact, the Arizona Supreme Court said, yes, you have your certificate of election. You get to go into the gubernatorial office and you get to be the de facto governor for the state of Arizona. And they made some very important findings because, again, it was not much dissimilar. There needed to be a transition of power. The transition of power has now occurred. We are now at the point where we actually have to take and get this right so that the constitutionally elected attorney general actually has possession of the seat in which they're elected. In fact, there's some very key quotes from the Campbell v. Hunt court. It is true beyond the pre-adventure of a doubt that the person who received the largest number of legal votes cast for the office of governor, in that case, attorney general here, is the lawful governor or attorney general of the state. Such person is now and always will be such until the term prescribed by law expires or vacancy occurs. Under the Constitution and the laws of the state, the real right or title to the office comes from the will of the voters as expressed at the election. If the office was in fact given by the voters to another, the mere canvass of the returns and declaration of the result and issuance of the certificate of election or any or all of these things do not and cannot invest one with the right which does not belong to them, to another. In a sense, if one has not the results and the evidence of the certificate based thereon. The canvass and the certificate of the Secretary of State are no evidence of who is in truth elected. They're only prima facie evidence of the results. What is prima facie evidence, or what is the evidence, are the ballots themselves. And the court goes to great pains to say that the ballots themselves are the evidence, are the best evidence. And we have those ballots, Your Honor. And there's been a couple of mischaracterizations. I think it started with us. We're not asking for a recount. We are asking for the court to count the uncounted votes, the votes that were erroneously marked as undervotes, despite the clear intent of the voter being expressed. We are asking for the provisional ballots that were erroneously issued and then ultimately rejected to be counted. The fact of the matter is this election is actually closer in margin than Hunt v. Campbell was. And at this point, we haven't even heard the defense say that if we were to count the votes, Mays would still win. Instead, they're afraid to even look at the ballots. And Your Honor, our Constitution demands that we do. The case law upholds that right. And despite the application that it's over as soon as the certificate election is issued, that's not what our case law, Campbell v. Hunt shows. And then its later case, Hunt v. Campbell. It shows that in Campbell v. Hunt, the court determined, the Arizona Supreme Court determined that the trial court was in the best position to determine the disposition of ballots and determine who actually received the most votes. And that's what we're asking, Your Honor, for here today. Either issues, whether it's the undervote or the provisional votes, are likely outcome determinative. Together combined, we believe, without a doubt, once we count the ballots, these ballots that were not already counted, Mr. Mohave will be Arizona's Attorney General. In fact, according to Campbell v. Hunt, he's already the Attorney General. I know that sounds odd. It says the person who has received the most votes is the person who has won. It just takes the court proceeding to ferret that out. So in Campbell v. Hunt, they declared the Mr. Campbell the de facto governor. So he sat there because it appeared on the prima facie evidence of the canvass that he was elected, but they had to determine the de jure governor who actually won. And that's already determined by the ballots. Like, we're not asking you to just randomly add ballots or subtract ballots. We're asking you to look at the evidence. And despite the fact that the plaintiff actually did a great point, I really want to thank them for making the case as to why a trial is actually critical. This is not an evidentiary hearing. So the idea that we would have the evidence to present as being the facts of the case seems to be a bit premature. We're certainly happy if this court wants to do a true offer of proof hearing to get past this stage. We're happy to do that. In the meantime, I have the declarations of hundreds of voters. Many of the people in this courtroom has actually interviewed these voters. They could probably testify as to who they've spoken to. I can tell you, I've got declarations right here, and they are in fact sworn. They say that they're saying them under pursuant of penalty of perjury. They know that these were provided for court for this case. We did not submit them in advance, partially because we'd like to make sure that the voter privacy is protected. And so we'd like to make sure these are submitted under seal when we do submit them. But ultimately, it's not the declarations that are going to determine whether or not these votes get counted, these provisional votes get counted. It's the voter themselves. And they can come in the courtroom, Your Honor, and you can cross-examine them. The other side can cross-examine them. But just to give you an example of one of the hundreds of declarations I have, we have Marlena. She, at the 2022 Maricopa County election, she went to go vote on election day.
Your Honor,
Provisional ballot.
Your Honor, I'm sorry, this is Ms. Daneman. This is testimony of counsel in a hearing on a motion. We would object to.
This offer, they said we have no evidence. I'm providing a sampling, but we can save this for trial. I'd be more than happy.
Let me rule on the objection.
I apologize, Sean.
There's no sense to argue. It is overruling the objection. Again, this is argument. I don't know what Ms. Wright's plans were for you and everybody else to see these at some point if they're trying to keep names secret or keep it on seal. But I mean, I'm going to allow her in oral argument at a hearing to argue this, and I'll make my rulings based on what I believe is correct and what's in the record at the end of the day, not at the end of today, but at the end of the process. So, Ms. Wright, continue.
Thank you, Your Honor. Marlena owns a second property in Pine Top, Arizona. She spends half her time in Fountain Hills, half her time in Pine Top. She always votes in Maricopa County because she's always in Maricopa County in November. In May of 2022, she registered her car through Service Arizona. She later discovered that her voter registration had been changed without her knowledge and consent. And in fact, I have the evidence that on October 10th, she attempted to change it back to Maricopa before the voter registration deadline had commenced. I have her evidence that she received from the court saying that, or not court, from Maricopa County saying she was in fact registered in Maricopa. She thought she could go vote because she had recognized there was a problem and tried to fix it. Your Honor, I've got hundreds more like this voter, and my intent for going forward, if we want to do an actual offer of proof and submit these declarations, I'd be happy to do that. We can do that and make sure that it does not become part of the public record. At least there's information, but we've got hundreds of these individuals that we believe can come into court and testify and be cross-examined as to what their experience was. But these are hundreds of votes that were not counted. So again, we're not asking for a recount. We're asking for these to be reviewed, and we can discuss more thoroughly at trial as to how we think that this happened, how the Service Arizona and Arizona Voter Information Database, the changes that were made over the course of the past few years. Again, good intention changes that resulted in more than 1,000 people being disenfranchised. So, again, as was said by the other side, we've submitted no actual evidence, and that is true, but that's what a trial is for. I think we've shown that we have enough evidence to bring us to trial so that you can more thoroughly examine the issues and decide for yourself which ballots should be counted and which should not. I think we've also proven, or I believe we've proven, that there's a need to see how the undervotes were cast. We're talking about a margin at this point of 280 votes. And we believe that there's at least 466 votes that were not cast, that were recorded as undervotes based off of just the calculations of 76,000 ballots. Either issue, 466, or the number of ballots that we found, the over 1,000 people that were disenfranchised. Either issue alone evidences that if we were granted a new trial, the outcome would be different. And by the end of the trial, again, we are not asking you to speculate. We'll ask you to count the votes. And we believe that the evidence is very clear that when we count those votes, Mr. Hamadeh will be Arizona's Attorney General. I just wanted to touch, I think you can do this for yourself, but I encourage you to read the Maricopa County recount order. I've read it several times over and over, and I don't see how it would have prejudiced the recount for her to confirm undervotes were in fact a problem. And certainly she had no authority, or nothing would compel her at trial to say that there was zero evidence that supported that undervotes were by and large not being counted, or real ballot votes were not being counted. And again, going back to the provisional votes, we believe that they're going to break for Abe Hamadeh based off of the fact that election day voters by and large chose Abe Hamadeh. Regardless of their voter registration, 69.21% of voters on election day cast their vote for Abe Hamadeh. 28.72% cast them for KRIS Mayes. This is all part of the Canvas data. We believe that once we count the votes, it will show, again, I think I had the delta of, it would be 700 and some odd votes for Abe, and it would be 300 and some odd votes, if I remember correctly, 200 and some odd votes for KRIS Mayes, and the delta was over 400, with Abe Hamadeh winning by about 120 votes. We think this is worthy of the court's time and attention. We think you're in the best position to be able to resolve the issues that remain. We believe that that's what Arizona's courts were designed for. And we believe that Arizona's rules of fundamental fairness, making sure that we get things right, not that we just speed through them, is important to the voters and to the citizens, to the constituents, to the people of the state. We thank you for your time, Your Honor.
Thank you, Ms. Wright. Mr. Zavalos, did you want to add?
Very brief, if I'm. One thing stood out today with me, and I hope with the court, that all we're doing is asking this court to allow that process to go forward, to in fact count the votes. It is a right that is hollow. If, as Jefferson said, the majority who vote really describe our government as a democracy, when in fact, if you don't count all the lawful votes, I've heard not one word in here today from our opposition, not one word, that the votes that we found were illegal or in any way not cast. What you have heard, what the record does show, is that the votes that were not counted should have been counted. And so if that's the case, the court has to have some basis upon which, as it does every single day in criminal and civil cases that come before it, to look at that evidence, give it that amount of weight under the rules of evidence it chooses to find. And by the way, your findings on that weight cannot, and I do not believe would ever be disturbed by a higher court, because you're the judge of that. But to draw direct evidence and something that's been left out of this proceeding, circumstantial evidence that goes on every single day in every civil and criminal proceeding, whether it's product liability, antitrust, it doesn't matter. It's evidence under our rules, under the rules in Arizona and every state I've practiced, that evidence is important and acceptable evidence, given the way it has to be given. I have nothing further to say except one thing that troubles me greatly. And maybe it's because I'm a little older than some people in here, and perhaps everyone in here, for sure. But I'm greatly concerned about something. And maybe if people that have been doing this, as I have, coming on 44 years of litigation, our country's in trouble because people are losing confidence and faith in their elected officials. We received a gift from our founding fathers, in my judgment, forgive me for saying it, but I've earned this in my age, from God. And it is no wonder that when we have people who are entrusted with the sanctity of our system, like Ms. Hobbs, whose conduct in this case has troubled me greatly, and I have to be careful, she's a public official, and I'm old school, so I need to be cautious in my words. But Your Honor, withholding votes, if delivered, is the stuff that makes some government agencies, at least in the past, begin grand jury proceedings. But if reckless or by innocent mistake, where was the lawyer representing Ms. Hobbs? As I had to recently in a brief I wrote to a court and discovered, oops, I was wrong. I didn't wait to come back from I'm your neighbor. I'm down in Henderson, Nevada, and in Phoenix working. I didn't wait. I was writing that thing in the car to tell the judge I apologize. I made a mistake. Why did I do that? Because it was a hotly contested issue, as this one is. And my duty as an officer of the court and the officer of the court for Ms. Hobbs should come forward, because we don't know whether what we say to a judge like yourself, Your Honor, or any other judge, how that judge might interpret that information. We don't have the privilege or the right to withhold information from a jury or a judge that's lawful, because we can't predict or look back with 20/20 hindsight what a judge would have done. I can't sit here and opine, and it would be unethical for me even to suggest what you may or may not have done, but you were deprived of that right. That's your prerogative, not a lawyer, nobody else. And it's your court that preserves the integrity of our country, and it's what will save our country from some of the turmoil we're seeking. And it's no wonder we come to court, because it is the courts, a free jury, a fair jury, that protects our society and our integrity. And Judge, that is what has been put in your lap. And I would apologize to you for having that burden, but I thank you for that, because it is people and judges like you that protect the sanctity of our country and can overcome the whims and travesties of the days we see today. I thank you for being permitted, Pro Vici, to appear before you. It was an honor. Thank you, sir.
Thank you, Mr. Zabalos. I guess how we're going to do this now, I would like to address I'm going to take under advisement the motion for a new trial, and that means I'm going to make a ruling hopefully within the next couple of weeks. And I put a date on here that I want to get it done, but I won't mention that out loud. The other issues that are still pending, I think the attorney's fees issue is something I probably don't need oral argument on. I can make a decision on that based on the pleadings that I've read, and I'll make that decision, and it could be dependent on the ruling for a new trial as well. So I'm going to wait on that. I do think that we should address the compensation issue. And I don't think anybody opposed the compensation. The issue is the amount. And I guess I was looking and didn't see, other than one reference to something that the judge in the governor's case did. I didn't see any history of what judges have done in compensating ballot inspectors in the past. And maybe so I guess I would just like, that was originally filed by Navajo. I guess I could let them start, and anybody that's joined in on that can speak to it, and just start that process just to argue that today. And I know the plaintiff again, doesn't oppose it, but opposes the amounts. And I'll let somebody argue that for them today. So Mr. Moore, if you want to go first.
Yes, Your Honor. The Navajo County filed a motion in this case that asking that the ballot inspectors within our county be compensated for their efforts and time in participating in this procedure. It really came out of a conversation that we had where one of our inspectors brought the issue up, and they were kind of assuming that they wouldn't be getting compensated, and I actually informed them that the statute, specifically ARS 16677C, made compensation for the ballot inspectors a requirement of the losing party. And so we collected information from each of the ballot inspectors within our own county for the time that they put into the ballot inspection process, including their time inspecting, as well as collecting information on the mileage that they put in. And so I didn't specify anything in the motion that's going to help the court out with regard to a suggestion for what the compensation should be. And the reason I didn't is because the statute doesn't give us any guidance on what the compensation ought to be. And I really don't necessarily feel like the county or my county is in a position to be an advocate, for these folks. We're just pointing out that the statute does provide a mandatory compensation, and that be paid by the losing party. And so I'm going to leave it to the real parties in interest to make argument about what they think that compensation should be. But I think, at a minimum, it would probably be, insulting to the ballot inspectors to not at least pay them minimum wage and to compensate them for their mileage. And so that's, really the only thing I have to say about it. Thank you, Your Honor.
Thank you, Mr. Moore. Who else? Does anybody want to address? I know Mr. Davis is ready, but I'm going to wait on. Anybody from Ms. Danneman or Mr. Morgan?
It's Craig Morgan, Your Honor. No, sir. Thank you.
I thank you, Mr. Morgan. Ms. Danneman.
No, Your Honor, I think the statute isn't clear about exactly what should be assessed in all circumstances, but it does say that the compensation shall be fixed as costs. And we submitted to the court the actual cost of our inspector's time.
Yeah, and that was, one of the inspectors at least was a lawyer making a large amount of money per hour. Was that one of the problems? Yeah. That's one of the things that came up. Mr. LaRue, did you want to address that?
No, Your Honor. Thank you, though.
All right. And Mr. Davis here in the courtroom, you wanted to address that?
Yes, Your Honor, only briefly. We submit, since the statute does not provide any form of formula or equation, only a reference or a guide that you may base your decision off of. We joined in Navajo and saying that we leave it up to the court. We included the attorney's hourly rate, and we referred as a formula to Rule 54 of the Civil Rules of Civil Procedure, only as a guide that you may consider when assessing compensation. Thank you.
All right, thank you. Ms. Wright, or Mr. Culligan?
Thank you, Your Honor.
Can you spell your name for the court reporter?
Yes, Your Honor. K-O-L-O-D-I-N.
Culligan. All right.
Yeah, I'll be extremely brief. We've heard a suggestion, minimum wage be the level for the inspection, perfectly acceptable to Mr. Hamadeh. We've actually submitted some material in our briefing showing that a rate of about $25 an hour would be appropriate. Obviously, that would also be acceptable to Mr. Hamadeh, but fundamentally, we are confident that we're going to prevail in this matter, Your Honor. And so to us, this issue, we would leave it in the court's discretion where to set that rate.
All right, and I think as I listen to this, I think that's where it is. I actually have to make a ruling on this motion for new trial. That affects that ruling as well. So again, it's order taking all the pending motions under advisement. Is there anything else you need to take up today, Ms. Wright?
Your Honor.
Mr. Eckstein, I'll ask you in a second.
Okay, thank you.
No, Your Honor. Thank you for your consideration.
Thank you, Mr. Eckstein.
Yes, the plaintiffs raised Hunt v. Campbell in their rebuttal argument. Ms. Danneman did not mention the words Hunt v. Campbell. I'm not objecting to their mentioning Hunt v. Campbell, but Your Honor, when you read the case, you will see that that case is so different than what is before you.
Mr. Eckstein, I don't want to reopen argument. So if I let you talk much more, I'll have to let someone else
I
begin.
just want to make one point. The point is that in Hunt v. Campbell, the parties stipulated to the procedure and to the recount.
And it was before we had a statute that actually dealt with recount. So all that stuff is different, and I'll definitely review all of that. All right.
Thank you, Your Honor.
All right. It's ordered taking this matter under advisement. We'll stand at recess, and I don't control the sheet.
Are we excused, Your Honor?
Everybody's excused. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Right?